Chapter 2. The relationship between doctor and patient. The relationship between doctor and patient, and thus any cause of action, can be based on a contract or in delict or both. Ordinarily, the contract takes the form of a tacit agreement where the doctor undertakes to treat the patient with the necessary care and skill, and the patient agrees to follow the prescribed treatment and pay the doctor's fee. This is mostly evident from the parties' conduct. Although this contract may be an oral agreement, it's advisable to enter into a written agreement when unusual procedures or more serious treatments such as hospitalization and surgery are necessary. Remember, it's important to establish if and when a contractual relationship started, the terms and conditions of the contract, and in which way the terms and conditions were breached. A valid contract comes into existence through the usual contractual requirements and requires no legal formalities. Consensus is reached based on offer and acceptance, which takes the form of the patient asking for treatment and the doctor providing it. Intention to create a legal relationship involves the intent to purchase professional services and the supply of medical treatment, and the contractual capacity of the parties is based on either the usual common law principles or legislation, specifically the National Health Act and the Mental Health Care Act. The legality and public policy of the contract will also play a role. The terms and conditions of the contract may be implied or express. The implied terms would be that the doctor undertakes to treat the patient with reasonable care and skill required by his or her position and expertise, that he or she does what they set out to do and complies with the terms and conditions of their agreement. Implied terms are further based on the trust relationship between doctor and patient and the fiduciary duties that go along with it. This entails that the patient puts his or her trust in the doctor arising from his superior knowledge and training. The doctor undertakes to act in good faith. Should the doctor fail in doing so, the contract has been breached. The patient may claim damages and the doctor may forfeit their fee. Express terms generally include the type of treatment to be provided, what program is to be followed, the identity of the parties, and the terms of payment. Similar to implied or tacit contracts, should the doctor or hospital fail to comply with the contract, they may be liable for damages and forfeit their fee. Remember that only patrimonial damages can be claimed based on breach of contract. The patient has the duties to subject themselves to the treatment, comply with the doctor's instructions, and pay for the services. Express terms are often found in hospital admission forms and may include exemption clauses to protect the hospital from liability. For the current legal position on this matter, look at Afrox v. Stradum, 2002. And to see a possible reform of this law, look at Barkhuizen v. Napier along with the Consumer Protection Act.